A notice of further authority was submitted by Ripple within the context of the SEC Ripple case. This was done in reaction to a ruling that was recently handed down by a court in another matter affecting cryptocurrency. This measure was taken as a manner of responding to the precedent that was established by the break. The Securities and Exchange Commission took into consideration the fair notice argument as a response to this, but Ripple did not bring it up in its response. An increased number of people became aware of the terminology that the SEC attorneys used as a result of this. And a large number of people became aware of the situation as a consequence of this. They have made it very clear that they have incurred losses as a consequence of the losses that have been occurring in the Bitcoin business, and they have highlighted the necessity of providing repercussions that are severe. In spite of the fact that it is not anticipated that the Securities and Exchange Commission will be granted its request for nearly $2 billion, the estimate of $100 million that was offered by attorney Jeremy Hogan is still believed to be excessive. In spite of this, it is not even close to meeting the threshold of $2 billion to be considered successful. There is a possibility that the information will be disclosed at any time, possibly on the same day as the announcement regarding XRP Victory Day, which was made on July 13, 2018. This event took place exactly 1 year ago. There is a chance that this could occur. In a letter that was written by attorney James K. Fallon, who represents the XRP community, it was said that Ripple has submitted a notification of further power in reaction to the recent decision that was made by Binance. This was stated in the letter. With relation to the conclusion that she arrived at concerning XRP and how it would impact the situation. In that particular case, the court agreed with the finding that Judge Torres had presented to the court. As a result of the fact that the asset in question is not a security, this occurs. Those individuals who possess XRP have achieved yet another significant triumph with this development. The notice of further authority that Ripple's legal representation has graciously provided is pertinent to Ripple's objection to the SEC's current petition for remedies and entry of FINA. L. Judgment. Ripple's legal representation has graciously provided this notification. The objection raised by Ripple is pertinent to the petition for remedies and entry of final judgment that was submitted by the SEC. In the context of the case of Binance Holdings LT, the United States District Court for the District of Columbia granted in part and rejected in part a motion to dismiss allegations made by the Securities and Exchange Commission that transactions involving specific digital assets constituted sales of unregistered securities. The allegations were made in the context of the case. The court issued both a memorandum opinion and an individual order in relation to the subject that was brought before it. Accordance with the structure that was created in the Howey verdict, which is only 7 pages in length. The argument that the court emphasized was that intangible digital assets do not fit very well inside the framework's parameters. Taking things one case at a time, coin by coin, and court by court is probably not the most efficient way to move either. In addition, it runs the risk of rendering decisions that are in conflict with one another, which could result in important parties and their prospective clients being left without clear counsel. The decision that was made by the Securities and Exchange Commission to monitor a corporation that is worth $1 billion through the use of litigation is probably not the most effective technique at this time. In the case involving Binance, the judge reprimanded the Securities and Exchange Commission for continuing to defend Ripple's currency after coin, coin after coin, in court after court. Ripple's attorneys continued to defend the token. The SEC was the target of the judge's harsh censure. According to the position that Ripple has taken, which is supported by this observation. The SEC is of the opinion that one of the most important outcomes that came about as a consequence of the actions taken by the SEC was the providing of clarity regarding the legality of the various sorts of sales of XRP. The decision that the Securities and Exchange Commission made to oversee the billion-dollar sector through litigation on a case-by-case basis, coin-by-coin basis, and court-after-court basis is regarded as dishonest and may lead to findings that are inconsistent. The SEC decided to go with this alternative. The decision of the Supreme Court in the case of Ripple Labs versus SAC, which was a summary judgment decision, lends support to the position of Ripple Labs, which is that the Supreme Court's finding of a strict liability violation on some of Ripple's sales, which is significantly less than the SEC's allegations of violations, does not reflect a reckless disregard for the law or warrant harsh remedies. The fact that the SEC has alleged violations lends credence to the argument that Ripple Labs has taken. In the complaint that was submitted by the Securities and Exchange Commission, there is not even a single claim of carelessness with regard to Ripple, which is an explanation that is entirely accurate. Despite the fact that this is the situation, Ripple continues to insist on a demand of $2 billion, which might be considered a form of unfairness that is justified. In response to the letter that was sent by Ripple Labs, the Securities and Exchange Commission stated that it will be providing additional information. The company Ripple Labs is of the opinion that this gives more basis for their resistance to the Remedies motion that was submitted by the SEC. The decision that this authority made on a request to dismiss a lawsuit that was filed by the Securities and Exchange Commission against Binance Holdings Law D is completely unrelated to the motion that is currently being reviewed regarding alternative remedies. On the other hand, Attorney Bill Morgan, who is a member of the XRP community, observed this and pointed out that the SEC is acting as if Ripple's attorneys are taking crazy pills in order to emphasize the significance of this matter. Morgan drew attention to the fact that the Securities and Exchange Commission SEC is handling the problem in this manner, despite the fact that the SEC has stated that this power is not pertinent to the case. At the same time that Ripple calls attention to a particular observation that is included inside the roughly 90 pages of the Binance order, it also makes an effort to extrapolate that outcome from larger observations on the effectiveness of the SEC's litigation strategy. Additionally, this verdict acknowledges the SEC's legal ability to exercise discretion in defining the manner in which a goad is carried out along the process. The statements that the court made on a motion to dismiss concerning the operations of the SEC do not follow the assumption that Ripple did not act with reckless disregard for the law in such a manner that heavy sanctions are not required. The court made these observations in this manner because it was emotional. The court made these observations after the request to dismiss, which is the reason why this is the case, in the most recent letter that Ripple has sent out on the elements of the ruling that rejected the fair notice argument as a defense to liability in the Binance court. The only aspect of the Binance verdict that may potentially be relevant to the remedial request is disregarded. The court decided that the defendant's assertion that the enforcement action against them presents a new positive rings hollow posture rather than rings hollow was judged to be accurate. Ripple has expressed their disapproval of this decision. After careful consideration, the court came at this judgment, if it had been brought to light. The fact that the Securities and Exchange Commission was only implementing a federal security act that was decades old, and an equally old Supreme Court opinion that interpreted it would not have been something that could have come as a surprise. This is because there were many cases that were filed many years ago. The Binance court also found out that despite the fact that the fair notice defense is an objective investigation, it was significant because the defendants claimed to have true warning that the SEC may pursue them. This was discovered by the Binance court, similar to the circumstance in which Ripple was given a specific warning on the dangers associated with its operations based on the advice of the counsel, but it nonetheless opted to persist with its activities. This situation is comparable. Because the fair notice defense has been failed in every cryptocurrency case in which it has been pled as a defense, and because it has not been successful in cryptocurrencies at least up to this point in time, but it has been unsuccessful in every other case. As a result of the fact that the fair notice defense has not been successful in the cryptocurrency industry, Attorney Bill Morgan has indicated that the Securities and Exchange Commission does not have any reason to be concerned about it. The implementation of the fair notice defense has not been successful in the field of cryptography at least up to this point in time, and it is a standard that is rather high. This is the case since the defense is a fairly high standard. Although Ripple had nothing negative to say about this subject, the Securities and Exchange Commission went to great lengths to bring it up so that it could be brought to everyone's attention. This was done in order to ensure that everyone was aware of. This incredibly essential aspect has been brought to everyone's